morning, counsel. You got your work cut out for you on this one. Your name?
Francisco Genson.
All right, so what happened is you guys were in here. There was a plea of guilt on July the 20th. And the other charge was that you stipulated we'd treat OWI conviction as to count 2, a non-technical, and R&O as to count 3. And we treated count 1 as a technical violation, which was consuming alcohol. I ordered him on a sober link at that time. And then and your name is O'Donnell?
Yes.
It says on August, so she said, see attached screening and police report regarding the new charge. You ordered for him to obtain did you get a chance to see this? This report that she did, prepared in the file?
No, Judge, I didn't. If it's just
Here, I'll just read it to you. It says, you ordered for Mr. Cantu to obtain a SoberLink device on July 20 when you last saw him in court. He did obtain the device on August 9. There was a positive blow on the SoberLink device at 6 p.m. with a result of .046, and then he failed to comply with the retest blows as follows on August 9th at 6:15, 6:45, 7:15, 7:45, 8:15, 8:45. And then she added on August, today it looks like, right? August 17th, over the weekend, the defendant tested positive on a SoberLink device and failed to comply with the retest blows. On August 15th, positive blow on SoberLink device at 6:25, and then failed to comply with the retest blows. So we've got 3 instances, correct me if I'm wrong, 3 instances where he tested positive and then didn't follow up with the retest.
So it's August 9th there was an incident, and then August 15th was the incident.
I see. My apology. I thought you were adding that on the 17th. So we've got 2 of those. So we're here for sentencing. I'll listen to anything that you have to say and we'll go from there.
Judge, if you recall, you also ordered my client to get into an IOP, and you ordered my client to finish community service. He finished his community service, and for both the case up north in Standish as well as this one, he was not able to get into IOP because he doesn't have the insurance. To his credit, I gave him a lot of places, and I believe that he called them trying to get those done. Judge, he's paid in full. And the SoberLink it's unfortunate, and tells me he didn't drink. Obviously, we all like to believe that. Would have been real simple.
Well, I'll give him a hearing on that if you want.
No, Judge, just what I'm saying is.
No, wait. Let's slow down.
Yeah.
If he says he didn't drink, I'll be happy to give him a hearing with respect to the SoberLink blows on August the 9th and August the 15th. I'll be happy to do that. That's not fair for me not to give him a hearing. If he's going to deny that he drank, let's have a hearing. If he isn't going to deny that he drank, then he can plead guilty to it. But I'm not going to proceed on the basis that he drank or didn't drink if he's denying that he drank. Right?
Understood.
So what does he want to do? If you need time to confer with him, I'll be happy to listen.
I don't need time to confirm. Can I approach with Mr. Brown briefly?
Yeah. Pull up the record.
Thank you.
You got to help him. He's going to.
No, sir.
He's either going to have a hearing on these 2, or he's going to make guilt on these 2. And so I'm going to do it.
That's what I'm approaching about.
I got to tell you what.
I know what I do. Oh, no, Judge, I'm coming up here to let you know that we're not going to play this game. My client, he's adamant. Didn't follow the rules of the song. He did get into the life. And that's it. If you'll take those, he's going to admit to violating his probation, and you're going to do what he's going to do.
But he's going to have to.
Oh, you want to hear him concerned? No,
He wants to have a hearing.
no. Okay, no, I don't think he's going to do that. I don't think he wants to do that. He was adamant about it with me. What he didn't do was all he had to do is sit around and do the retest. That's what
He's going to get that he drank.
okay. Understood. then Judge, I get it. But I mean, my client is ready to accept responsibility, go to the max of what you have at your disposal, which I think is,
Well, that,
and he knows that.
that's fair. But he's going to have to get rid of it, right?
Judge, here, that's what I approached. Let's pass it for a minute so we can talk to him.
Thank you.
Appreciate you.
Thanks.
Yep.
Madeline, let me call you later, wherever you are back there. I saw you. Let me call you later, okay? Alex Trebizio, 260843982. Thank you. People against Francisco Elijah Cantu, 250244762A. All right, Mr. Williams, what is your client going to do? Can I have everybody's name, please?
D. Todd Williams, appearing on behalf of Francisco Cantu.
Francisco Ganson.
So is he going to acknowledge that he consumed alcohol on August the 9th and 15th, or what's he going to do?
This is what we're going to do, Judge. My client conferred with his schedule and his phone, and even texted his girlfriend. He's adamant that he did not drink the 9th or the 16th. However, Judge, on August 1st, when we were in the hallway discussing, he goes, Todd, I didn't drink last week, but he goes, but I drank August 1st, texted with his girlfriend, confirmed it. He took his last sober link at 10 p.m. on August 1st. He and his girlfriend consumed alcohol on August 1st. He did not test positive in the morning on August 2nd.
August,
1st. My client.
yeah, I know, but August 9th and 15th, you say you've got a positive blow, right?
Correct.
So we're going to at least have a hearing on this, okay? So he can admit he consumed alcohol, he can deny it, it's fine that he's denying it. We're going to have a hearing on those two, and I'm going to make a determination as to whether or not he consumed alcohol on August the 9th and August the 15th. All right? That's what we're going to do. Raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got.
I do.
Go ahead.
2 counts. My first count is on August 9th. There was a positive blow on the Soberlin device at 6 p.m. with the result of .046. The defendant then failed to comply with the retest blows as follows. These are all dated August 9th of 2026. He failed to retest at 6:15 p.m., 6:45 p.m., 7:15 p.m., 7:45 p.m., 8:15 p.m., and 8:45 p.m. My second count is on August 15th of 2026. The defendant submitted to a Soberlin blow positive at 6:25 p.m. with the result of .076. The defendant then failed to comply with the retest blows as followed. These again are all dated August 15th of 2026 at 6:40 p.m., 7:10 p.m., 7:40 p.m., 8:10 p.m., and 8:40 p.m., and lastly 9:10 p.m.
All right. Do you have any questions, Hal?
I do. Also, Donald, it's possible in your experience, an individual test and think they passed the test and walk away from the machine instead of going back and reloading, whether it
It could be possible. Every time they're instructed on the device, though, they are told to make sure the device is submitted. A lot of times when the device is positive, it'll show that it says retest in 30 minutes. So they're always, responded to make sure they take a look at the test to make sure it's submitted and that there's nothing.
So in other words, if an individual like Mr. Cantu gets comfortable, so to speak, with passing tests, goes in, blows, folds it up, closes it, and doesn't follow it, then it will go through the protocol showing that he failed to retest. So it is possible in certain circumstances that there could be an initial positive, waiting for the reaffirmation. But if the client doesn't follow the instructions, doesn't read the instructions, doesn't listen to the demonstration and picks it up, that they could, in other words, they lost the opportunity to prove that they hadn't drank alcohol.
It's definitely possible for her to do so.
So we don't have 100% confirmation that he drank alcohol. However, there was the BAC accepted by the machine, but because he didn't reaffirm that he retested, low number.
Perfect. Those retests would have been able to confirm if it was an actual positive or if it was from an environmental factor, because those retests would have looked there.
But we are confident that he had those instructions, obviously, because there were several other tests we did it right.
I have one question as you look back in your notes. Did he ever have another instance where he did have a positive reading And then you did follow up with the reaffirmation, the retest?
No, he did not.
Thank you. I have nothing else, Judge.
Does he wish to testify?
No, Your Honor, my client didn't stop.
Any argument?
Judge, other than obviously we had a positive test, it's unfortunate that he didn't get back on retest. Other than that, I hope you take into account that my client did admit to consuming alcohol against your orders on August 1st.
All right, the court finds the defendant did in fact consume alcohol on August the 9th, that he tested at .046 and then failed to submit to the retest, and furthermore, that he tested positive on August 15th for alcohol and then did in fact consume alcohol, and he had a .076 reading and then failed to submit to retest. So this is where we are. I want you to remind me, on the drunk driving it was adjudicated, that was in Standish, correct?
Correct, Judge.
How many days did the judge give him there?
Judge, it was 24 days he gave him, and I believe he did 19 days.
Anything you'd like to say before I sentence him on this?
Process goes with a few months out, Judge.
Definitely, not proud of my decisions so far, but I definitely feel after everything's said and done that I will learn my lesson. And that's,
Did you ever talk to your probation officer about the fact that you didn't have insurance to get an IOP?
I did mention it one time.
We did, we talked about the 1-800 number. He was going through, I believe it was Sacred Heart, and Sacred Heart will take you if you don't have insurance.
Right.
You go through, the questions and everything like that. I'm not sure if he went through all of that with them, but I know he was in contact with Sacred Heart last time.
Did you?
I contacted them and they said that they didn't have a IOP in their area. So they gave me a recommendation number, and that person ended up giving me multiple different numbers that I called, and some of them were a bit expensive, like $200, $300 a day, 3 times a week. And I can't afford that out of pocket.
Anything else, Mr. Williams?
So other than he completed not only his community service for here in Standish, and that was the last hurdle that he had for Standish, paid his money in full, and
He's paid all ours.
credit. He has, as well as other more.
Judge, I would like to add just for us, he has 4 days credit jail. For 1 day that he served while he was in custody when he was arrested, he did 2 days on the court work program, and then he completed 1 day of community service for us.
You know, your lawyer gave a very spirited argument when he was here before, and he did a really good job for you, but he can't save you from you. There's no doubt in my mind you were drinking after we had that hearing, whether it was on August 1 and certainly, I believe, and found on August the 9th and 15th. And after you went through 2 drunk drivings, I would have thought you'd stop that. I get the fact you had an addiction problem, but you made up your mind for whatever reason you couldn't go to IOP, and then you still kept drinking. And the reason I wanted you in IOP is I wanted to help you. And frankly, I'm not sure I would have done what I'm doing today had you followed the rules and been abstinent from alcohol and drugs. I'm sorry, probation's revoked. You're to serve 45 days credit for 41. I won't assess any costs. You've already paid that. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer. Thank you, Mr. Williams. Have a good
Thank you,
day.
Judge. Thanks for the side consideration.
Have a good day. Nice to see you. Haley Clark, I'm sorry.